Hello there, my name is Cathy of Brevin & Co. We're accountants and financial planners, where we create a better financial life for our clients. While people expect the bare minimum, we challenge them to expect far more. This video provides general and factual information known at the time of production and should not be used as advice, as your circumstances are unique, and this video has not taken that into consideration. We recommend you reach out to us and get specific advice relative to your circumstances. We have Hannah Andreyev from Andreyev Lawyers with us today, and I will post at the end of this video her contact details, so if anyone wants to reach out, they can contact her. So welcome, Hannah, and thanks for joining me.
Thank you, Cathy.
Now, I wanted to jump and dive deep in to find out what is the weirdest thing you've ever seen in a will.
Well, I was thinking about that. Usually they're more mildly amusing than totally weird. So I always get quite impressed at how much money people leave their pets. It can be hundreds of thousands of dollars. And you sometimes think, oh, I wouldn't mind looking after those dogs. The other one that caused me to laugh a bit lately was this gentleman who was leaving his family his mobile phone and his digital camera, and he left really long and explicit instructions about how everything was to be wiped off these devices and they were to be returned to factory settings. So I was sitting there sort of mentally speculating, like, what could be on these cameras and phones? But you know, you do read about crazy stuff, and probably a very famous South Australian example was the one of our former Lord Mayor's wives was estranged from her daughters, and she first off started leaving them 30 pieces of silver for their Judas-like acts of betrayal. I think she believed that they had been trying to kill her, and then she topped that one off by saying, "Well, you can have my jewellery though, provided you read my diaries," and it was from quite a long period of time, and then answer questions about them. And if you get the question, answer the questions properly, then you get your inheritance. Oh. So there's certainly sometimes you're sort of guiding people out of that kind of bequest.
Very much like ruling from the grave, really, isn't it?
Well, it's sort of putting the knife in, because of course this family went off to court to see if they could have this will thrown out because mum was obviously insane. But the court upheld the will, and they also refused to strike out or at least not publish the contents of the will. So that's why we all know what was in this will, because the court allowed the will to be published. Essentially.
Oh, wow.
So you've just got to know what you're doing. I think those revenge wills are always quite interesting.
Yeah, absolutely. But I suppose that then begs the question: why have a will at all? I mean, I've heard you speak on people getting the $5.50 will kit from the stationer's store. So why bother having a will?
Well, yes. Well, in those situations, I think they're obviously trying to create a problem. So, they're trying to be creative about how to do that. But I think, generally speaking, for most people, a will is going to be useful for the family. People usually have something to leave, and I think on average, it's most people die with their own home and some super, and you're sort of looking at between maybe 300 to 500,000 as a minimum, more like 800,000 that people are dying with. So when we're talking about that kind of money, it is worth preparing a will, even for smaller amounts. Recently I had a client who had $50,000 to leave, but he wanted to leave it in unequal shares to his children. So if that was his wish, then you've got to put that in your will. Otherwise, you die intestate, and the court will basically divvy it up equally between your children. And that wasn't what he wanted. So you make a will in order that what you give your family goes to the right people. Otherwise, there will be a dispute. So really, a will is all about avoiding a dispute if possible.
And why wouldn't people just do their own will, write up their own requests? I've heard of letters of wishes and things like that.
Yeah.
Why use a lawyer?
Once again, it's quite a complicated area of law. It seems simple, but wills have been around as long as I think humans have been around. So lawyers have had plenty of time to complicate things. And so what you think you're doing might not be actually what you end up doing. So a legal input is useful. There's a lot of points of decision making where having the right, like if you appointed your minor children as the executor of your will, for example, or if you, decided that you were going to exclude someone from your will, or one of the things that I see all the time is that people don't know how they own their property. So there's a lot of cases where people try and leave assets that they don't own in their own name in their will. For example, they might say, all my super goes to Cathy, but you can't do that in your will, and they might not know that. And just by asking a lawyer, that will end up with the right person. So there's a few tricks to writing a will. And if you want to really look after your family.
Yeah. Does that, if they put something in there that's untrue or untrue or false in law, does that then void the will?
Well, that gift, yes. So if you attempted to leave a gift that was not yours to leave, then that gift fails. And you've got to be a little bit careful about wills, because sometimes you can write them. Let's say I leave you $100,000, Cathy, and you die before me.
Yep.
And what if I have got nothing in the will then that says what happens to that $100,000 if you die?
Right.
All of a sudden, that $100,000 becomes part of an intestate estate. Basically, I've not made a will for that $100,000. So the family have to go off to court and work out who gets the $100,000.
So that's a good reason to actually review your will on a regular basis.
Yeah, I mean, specific gifts are always a little bit tricky, because the other thing that people do is sometimes if they've got an enduring power of attorney in place, and their attorney, say, sells the share portfolio to support somebody in a nursing home, and yet in the will it's quite clear that share portfolio was to go to one of the kids. And all of a sudden, they've missed out on their inheritance. So you've got to know how to deal with that. Now, we do have laws in Australia that deal with that kind of scenario, but that's not uncommon. And those laws are fairly recent. In Western Australia, they don't have laws about that. So yes, keeping your will up to date, knowing how you own things so that they actually can be left to someone in your will, and then always having a bit of a backup plan so that if a gift doesn't make it to one person, there'll be someone else who will receive it. That's quite important.
So how can you contest a will? Or who can contest a will? And then how do you go about doing that?
Well, that's dictated by legislation. And the thing about wills and administration and probate law in Australia is it's different from state to state. So if we're talking about South Australia, that's governed by the Inheritance Family Provisions Act. And there is a section in there that lists who can contest a will. Basically, you contesting a will, there's two sort of types of contesting a will. You might be arguing that a will is invalid because of somebody's lack of capacity, or that they were coerced or threatened into making a particular will. Or you might be just saying, look, this will is unfair. I was not adequately provided for. And there's a certain group of people that can make that argument. And they fall into close family members like spouses, de factos, children, grandchildren, stepchildren. It's a reasonably broad category, but the further away you are, the older you are, the better off you are, the less likely it is that your claim is going to be accepted.
Right. Yeah. So get advice is what I say.
Yeah. I think
And
when
so,
people start playing around, and sometimes it's, people try and do the right thing and it doesn't end up that way. So one of the famous cases in South Australia was a will where this woman left her estate equally to her 3 children. So that would seem very non-controversial. In that case, however, there was one of the sons sort of looked after her financially. The daughter was there every day, cooking breakfast, taking her to doctor's appointments, that kind of thing. The 3rd son lived with her, and he was one of these people that just failed at life. He was an alcoholic. He had incredibly poor health. He had mental health issues, unemployed, you name it. He was, he was just there living in his mother's house at, long after he should have been.
yes.
He made a claim saying that he had not been adequately provided for. Once the house was sold and they all got their $200,000 or $300,000 each, he would not be able to buy a home to live in. Like, essentially, she had given away his home, and that was unfair. And the court actually entertained that case. They divvied up the estate so that he got a greater share of it. And they placed great emphasis on the fact that although he seemed to contribute nothing to his mother, the fact was she had Alzheimer's. And just by being in the house, that was a significant contribution. Plus the fact that had he not won that case, he would have been a burden on the taxpayer. So, sometimes I think the court says, well, who should pay for this person? Should it be the family or should the taxpayer pay for them?
Yes. Well.
So that's, I think, where the family gets really annoyed, because they're definitely saying the taxpayer should be paying for that, Lisa, not me. But the court sees, public policy says otherwise.
Very true. So with all of that, and like this morning you spoke about, I heard you talk on a famous case with Peter Brock, and, people, as a financial planner as well, I get told that, we'll get to it with regards to doing the will, and 5 years later they're still getting to it. Any tips on people getting, any tips that you can share about encouraging people to get their wills, and even enduring power of attorney and aged care directives, all the estate planning documents organised?
I think there's a lot of excuses people put forward. They think, I think the main thing is they don't have a lawyer they can trust. This is a completely new space for them. Am I going to get ripped off? I'm going to be presented with this document full of gobbledygook. I don't know if it's saying what I want it to say. There's that whole trust level. There's that access to justice, which is a real issue in Australia, and a podcast for another time. But I think now with the internet, you really can Google around and you can find somebody that you feel comfortable enough to talk to. And most lawyers do speak to you for at least 20 minutes or so over the phone, and you can get a feel for how much it's going to cost, what the process will be, that kind of thing. The other stumbling block, I think, is people think it's too hard. They've got to make too many decisions. It might be a case where you're a blended family, and you're thinking, how do I look after my children from my first relationship and still provide for my second spouse?
Yes.
Someone's going to be upset. You're not inventing the wheel here. There's a solution. Nothing's perfect. It would be so nice if you had so much money that you could just leave massive amount to everybody and everybody would be happy. I have to say they're never happy even in that case, but you can have a workable solution. And I think in particularly blended family cases, you've got to be able to communicate what you've done quite early. So you can identify if there's going to be a problem. And if there's going to be a problem, you can sort it out in your lifetime. I think the instructions I hate receiving the most are the ones on people's deathbeds in a hospital. That is the last time you want to be making decisions. These decisions have been so hard, and they're not going to get any easier if you're in hospital making them. And then, of course, because you're in hospital, giving will instructions to someone like me, then there's going to be questions of capacity. That this person has got cancer, and were they on drugs? Have they lost some sort of mental clarity? Did they really and has this exploitative lawyer come in and made this will for them, and it always ends up with me going into court, which I hate. So those are my least favourite scenarios, because they will end up in a dispute, and really, you've left it too late to do any clever structuring. This is one of the things that I often talk about in South Australia. We hear a lot of cases where wills are challenged successfully, and a lot of those cases are New South Wales cases, and the law is different in New South Wales. In New South Wales, everything that you have some sort of ownership or control over, your superannuation, your life insurance, jointly held assets, even transfers that you've made in the last 3 years, they can all be clawed back in and subject to an estate challenge. In South Australia, that's not the case. The only assets that are vulnerable to a challenge are those that pass through your will. Right. So, that's the key thing. So if we're talking about maybe you wanting your superannuation to go to your spouse and your primary residence to go to your children, you can actually, and you think there's going to be a dispute, maybe both parties are going to dispute, you can make a binding death benefit nomination to your spouse, which is likely to be upheld, and you could even make your children, the joint owners of your house, so that it automatically goes to your children rather than goes through your will when you die, or perhaps better yet, put it in a trust. Yes. So that when you die, like you can own it jointly with the trust, when you die, your share goes to the trust, and you can pass control of the trust outside your will. So, there's lots of things we can do in South Australia that you can't do elsewhere. No. And it sounds very, to the layperson, I would think that would sound all gobbledygook to them. So clearly my recommendation is to go and speak to you and get advice along with your accountant and or financial planner, because working together we can get all of that set up and organised for you in the way that you want it to happen, or the client wants it to happen, I should say. One last question before we finish off. You talked about interstate laws being different. And this is just something I thought of, can lawyers from other states prepare wills for clients in different states? Yes, absolutely. We have it's a constitutional right to be able to practice law throughout Australia. We don't have we'll have separate registrations. You're allowed to practice law. Some people don't because of insurance. You are more likely to make mistakes in jurisdictions that you're less familiar with. But with wills, I think where it can be tricky is if you went interstate to make your will and you owned all your assets here in South Australia. So let's say you made your will in New South Wales, but you owned your real property in South Australia, and the governing law might be New South Wales because the lawyer in New South Wales drafted the will and they just automatically did that. You could perhaps get into a dispute over what should be the correct jurisdiction for that will. The people in South Australia would be definitely arguing, particularly if there was a dispute. No, it's the South Australian will. And in New South Wales, they might be saying, oh no, it's a New South Wales will. So, but yes, we can write wills wherever. Perfect. Well, thank you so much, Hannah. I think that was very informative, and hopefully people got some value out of it. And as I said, I'll put up your details on the screen, and they can contact you or contact me, and I can put them in touch with you. So thanks again. That'd be lovely. Thank you, Cathy.